Hello, everyone, and welcome to another episode on Immigration and Jobs Talk Show. I'm very happy to be here. I am Nipasa Pradhan, and welcome everyone, wherever you have joined us from, whether on Facebook, LinkedIn, YouTube, Twitter. Thank you, everyone, for joining. And it's going to be an amazing webinar today as well, with a face you already are familiar with because we've had so many webinars and episodes with none other than Prashanthi Reddy. Yes, Attorney Prashanthi Reddy, welcome to our show. Thank you so much for joining us today.
Thank you for having me.
How are you doing today, Prashanthi?
I am good, very good actually. So yeah, I'm glad to be
All
on the
right.
show.
Good to have you. Good to have you. And today, friends, we will be discussing about unveiling the H-1B cap filing chaos, revealing shocking do's and don'ts. And it's going to be a very, very interesting session. So be with us. And Prashanthi, maybe you could tell folks out there what can they expect from us today.
Yes, so today we thought we would, of course, take your questions. That is always number one priority for us. But we would also talk about a few topics on how to file, really, because this is cap season. So, how to file a H1, what processes to follow, and some do's and don'ts on what to do and what to avoid doing when you're filing your H1B cap petition.
Right, right. And Prashanti, though they are my questions, but they are the questions which we've taken up from the audience. And absolutely, friends, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, thank you for this. And let's move ahead, with this first question I have for you to start off our show today, and it is the current visa status of an individual affected when a company applies for an H-1B visa on their behalf? In simpler terms, can the individual still enter the US or for non-business purposes during the H-1B decision process?
So yeah, the I think just to simplify the question, um, what is the current status? So there is no status that a H1 that a person has while their petition is pending, right? The status only occurs when the petition gets approved. So if the H1B petition is in process, they currently have no status with reference to that H1. So if they are seeking to enter the country, say on an F1,
Mhm.
then they can do so. The only thing is that that H1 that was filed most probably was filed as consular processing because they're out of the country, I'm presuming. So if they wanted to get onto that H1 status, then they'd have to file for, they'd have to then leave the country and come back on that H1.
Okay, and what if an individual is currently in the US for a visit? Must the company wait until they depart before initiating the H-1B application?
If it's a regular application and not subject to the cap, then you can file a change of status from a B2, which is a visitor's visa, to a H1. The tricky part is when you're filing a cap petition because you're usually filing 6 months in advance. So when you're filing your cap petition, you're filing, say, in April or May, before June for sure, because that's the deadline. And you're filing for a start date with October 1st. So that person who is on that visitor's visa must have a status until October 1st. And usually it's difficult for somebody to come on a B2 and stay for more than 6 months, right? Usually they don't give more than 6 months on the B2. So you'll have to file an extension to ensure that you remain in status until October 1st. So it's a little tricky. But say you came on an F1, and you want to file a change of status from an F1 to H1, that's of course easier because an F1 has something called a cap gap, which allows you to um, extend their status until October 1st artificially uh, through the cap gap process.
Thank you, Prashanti, for taking that up and making it clearer for us. And I'm sure folks out there are very interested. And I'm so happy to tell you, Prashanti, that many folks have joined and they already have questions. So I think we should just pick up one so that they can stay with us. And that is on YouTube from Design asking, my H-1B got picked up in March 2022. Then my case forward to DOL. And after some time, my case is in audit. How much time does it require for H-1B audit cases?
I don't think the fact pattern makes sense here because usually when it's a H1, it doesn't go to the Department of Labor. It goes to USCIS, US Department of Homeland Security, Immigration Services. So there's some mismatch here. We should ask your question again. It won't be forwarded to DOL ever.
Okay.
Um, he says that his H1 got picked in 2022. So that's a while ago.
2 years
Um,
ago.
2 years ago. So a H1B, even if it's audited, I don't know what. Maybe it's audited after the H1 got approved. Can you send us some more information so we can answer your question rather than speculating? Send us more
Sure.
information on what got sent to DOL and what is your present status? Are you presently on a H1? And so it could be that the H1 was audited by the Department of Labor, and that's possible after it gets approved for it to be audited. So send us more information, and we'll be definitely
Raza, we are
answering.
here. Yes, we'll be here for almost an hour, 40, 45 minutes. So please tell us more about your case and we will surely take up your question. All right, so let's move back, Prashanti, and there's also a case study. And what do you suggest? A consultancy offered to sponsor someone's H-1B visa. And recently they notified them of their selection in the lottery and provided the I-9797C form. Now they're requesting payment for petition filing. So how can the person confirm their authenticity and ensure that they are not being deceived? The person even reviewed their previous filings in the USCIS database and found two successful H-1B petitions.
There's no way of, I mean, you should get an approval, like you said, if it's been picked, the registration selection form. If it's there, you can compare it to, go online and compare it to what a form should look like, and that should give you some idea. Also, you can ask them to send you a screenshot of the submission page, and there is the portal, the copy a screenshot of the portal and the submission page, and the proof that the case was actually approved in the registration. That is possible, and that should give you an idea because that will have all the information: your name, the list of cases that were submitted, and the status on each case. So that should give you an idea. With reference to payment, that's a different story completely. The petitioner is not supposed to take payment from the beneficiary for fees or anything for that matter. So that's something that then the employer will be in violation if he is taking the fees for filing the H1 from you.
That's interesting. And okay, I think so. Yes, maybe because he was asked for payment, that's why he had this question and doubt. What should he do, whether he should proceed or not? So thank you for taking that out, Prashanti. All right, so there's another one since this is about do's and don'ts. So maybe if you could suggest, three alternatives if your H-1B application was not chosen this year, what can people do?
Well, you can file for a different application. You can, of course, go to a student visa and then work on CPT or OPT there. You could file for a TN if you're from Canada. You can file for E2 if you're from Australia. They're all similar visas to the H1 work visa, of course, but you have to be from those nationalities of those countries. And you can file for an L1A or an L1B for many nationality if you qualify for an executive position for an L1A and a specialized occupation, a specialized knowledge position if you're on L1B. So there are some options, but you need to see if you qualify or not. You can also do an O1, which is for extraordinary ability. So not everyone qualifies. So these are some options that you some other work visas that are available. And of course, you could file a green card directly if you qualify under EB1, and if you belong to someone who is worldwide, that is not Indian or Chinese nationality, then you can conceivably file for a green card and come here within a year or two on directly on a green card, employment based visa.
Okay. Thank you. That's interesting. And they are the options, friends. So you can definitely choose one. H-1B is not the end if that's what you were always hoping. There are more options. Just stay positive. Okay. And let's move on. Prashanti, what about the implications of filing an H-1B visa application for a company with less than 5 employees, particularly, when the first employee sponsored is for an H-1B?
That doesn't the size of the company has never really mattered to USCIS, nor does it matter that how many employees you have or what revenue you have, or whether this is your first H1 or you've done H1s before. What matters is, in that particular case, whether you have the ability to pay, the ability to hire the person once he joins. So they're going to look at what job you have for that particular employee. So they're going to look at whether this is speculative employment or you actually have a valid job offer. So as long as you provide information to them showing that you have a valid job offer and what that job offer is, and documentation such as, I guess, client letters or POs or work orders to show, or other documentation to show your volume of business, or an explanation as to why you need that particular employee to work for you. It doesn't really matter, what your present revenue is or how many employees you have.
Okay, okay, thank you. And I'm very happy that Raza is there and watching us. So he's clarifying more and saying that I-797C shared with me by employer audit from USCIS H-1B case.
He's still being very cryptic. You should tell him that there's no limit on the number of words that he can use when you ask a question.
Okay.
Raza, sorry. But it's still not clear as to what you're asking. But I'm going to try and answer anyway, based on what I understand. Whether it's, then, yeah, for those other people watching, please make sure you ask your question and use the sufficient number of words to, ask your question so that there's no issue. So, looks like his USCIS H1B case is an audit. He doesn't say DOL anymore, so I'm presuming it's not DOL.
Mhm.
Uh, so there could be an audit for many reasons. And again, it's hard to say why there has been an audit. It could be that USCIS is looking at the case because you're at the consulate, you applied for a visa, and they've sent it. The consulate has sent back, a letter or correspondence to USCIS asking them to look into it and verify whether the employment is valid or not. It could be that you've already started working, and there's an FDNS visit, or DOL audit to the employer's office, and he's being visited and audited for some reason, maybe with reference to salary, it could be work site, there could be numerous reasons. And with reference to processing time, on how long these cases take, that is, it can take, depending on the seriousness of the case, it can even take a few years sometimes for them to complete their audit. Sometimes it could just take a few months. And usually they don't give you any information once they ask for an audit, unless it's negative information to give you. And they're revoking it. They don't usually give you any information saying that the audit has been approved. So no news is good news in this case.
Okay. Thank you. And Raza, I hope you got your answer. If not, please make your question a little more clearer. And just like Prashanti said, there is no limit to words. So you can tell us all about you. What is your situation right now with your visa? All right. Let's move on. We have Samsonite saying, "Hello, team. I have a lengthy question I will ask in few parts. So the first part is asking this question on behalf of my friend. Below is the question 2021. His employer filed a perm and that I-140 got an RFE and was denied due to location change. And the part 2 says 2022, his employer filed another perm and I-140 got an RFE and was not responded by his employer. 2023, his employer filed another perm
Wow.
and is in process for almost 10 months. He has already maxed out his H-1B in 2021, and his H-1 was continuously requested for 1 year extension after sixth year with the help of existing perms. And the part 4 is asking, now he wants to know his options of getting his green card approved after getting RFEs continuously for 2 times.
Well, again, not enough information. We don't know why. Okay, first time we know
Oh,
that,
wait, there is
yeah.
more. There
Okay.
is the fifth part asking, and how should he proceed on his next I-140 filing after his perm gets certified? Also, his H-1B extension was filed in September 2023 and still in process. Wanted to know on next steps.
Is there anything else further?
That's it.
Any more
That's it.
parts?
That's it.
So I have to remember the 5 parts and now answer the question.
Let me just
No,
have
it's
them
okay.
for
I'm just
you.
kidding. I'm just kidding. I got it. I got it. So um, basically, whatever he's given us some background that the perm was denied twice, and it's filed a third time, and it's been 10 months since it is now pending. It's pending. It's pending. You just have to wait. Um, until it gets approved. Though 10 months for a perm is usually a long time. Should be approved in 6 to 8 months. So could be that there was another audit. I'm not sure what the situation is. Um, on getting his green card approved after. So there's no reason why the green card cannot be approved after previous audits unless there was something again with reference to the employer and that whatever the issue was not being resolved and the perm was filed incorrectly again. If all it, then of course it can be an issue, continue to be an issue. But if it was filed correctly and if all the issues were resolved from the previous time, then you should be able to get the perm. I don't know why it's taking 10 months. Maybe it's been audited because previously audited, so they tend to, it's possible that now they want to audit it. It could be that it'll go into supervised recruitment. This happens when there are issues, and then the labor department will ask them to employer to redo the ad and send the resumes directly to the Department of Labor instead of sending the resumes to the employer, and then they conduct the recruitment. And so that's a different process. And usually, when it's supervised recruitment, it can take some additional time. But barring that, if it's 10 months, you should be getting your labor approved soon. And if everything is done well, you should be able to file the I-140. Previous denials are not um, does not bar you from getting a approval this time if all the issues have been rectified.
Okay, thank you so much for that. And Samsonite, I hope it's all clear. If you have more questions, we are here. All right, let's
You're
move
actually
on.
rhyming. Did you realize that?
Yes, I am becoming poetic. Just kidding. But yes, all right. So let's move on. There are so many questions from the audience. I think we should just move to them,
Yes.
Prashanti.
Yeah.
All
Yeah. Yeah.
right.
Absolutely.
So let's move on to Mahit. Mahit is asking, hi, madam. An unidentified individual attacked an F1 student with a glass bottle, resulting in severe damage to the student's car windshield. The police issued a report citing criminal mischief to the F1 student. Despite this, the student continues to experience feelings of insecurity, threats, and significant mental distress as a result of the incident. Need immigration attorney's opinion on this. So, what do you suggest?
There is no question here. I wish would Mahit today. People are not asking me questions and make it difficult for me today. So,
Okay,
uh,
but the
you
situation.
can
So,
ask
what
the
should Mahit do?
question. Yeah, what is
Okay.
the question? So, this is mental distress, insecurity. I understand. I sympathize. I'm sorry that this happened to you. But what is it that you need? How does this affect your immigration status?
Okay, Mahid, if you could tell us if you're facing any difficulty about this, with regard to
With
your
reference
immigration
to your
status.
immigration status, then let me know and I'll be happy to, answer questions related to that.
All right, Mahid, we are here. Let us know. Okay, Prashanti, I think we should move on to Anas in LinkedIn asking, unfortunately, I haven't been picked up this year, but this session was very useful for me. Everything was in detail. Thank you very much. Okay, sorry,
Okay.
there was a previous question. There was a previous part asking, no, it's the same.
I guess it's a comment and they're just be
It's a
thanking
comment.
us.
Yeah.
Thank you
But
so much
okay,
for thank you so much for appreciating the show.
cool. All right, so thank you so much. Let's move on. We have Om Prakash also with, okay, this is another, sorry about that. Okay. Rihanna asking, what are the key documents and evidence required for a successful H-1B cap filing?
Yeah, so there you have to make sure that your employer has the ability to show that they have a valid bona fide job. So they should definitely submit documentation to show that, such as, if you're working for the employer directly, then they should submit their contracts or information that will allow the USCIS to see the volume of business that they have, such as the bank statements, maybe the tax returns, their contracts, client list, etc., just to show that um, they require your services. Also, if you're presently in the US, then you need to, of course, show that you're maintaining your status before you file for a change of status. So all those maintenance of status documents are essential. Your I-94, whatever it is. If you're on an F1, then your I-20s, letter from the school showing that you're presently maintaining status. If you're on a H4, then maintenance of status would involve your I-94 and your spouse's H1 approval and their pay stubs to show that they're maintaining status, because your status as a dependent really depends on their status. So maintenance of status is important. Availability of job is important, and of course your passport is important. And you have to make sure your whoever is submitting the document, the case for you, properly fills out the forms, properly describes your job to show that it's complex enough to require a bachelor's degree in a specific field. Also, your degree copies are important, in transcripts to show that you qualify for the job, and uh, the degree has to be related to the job that you're doing. Say if you're working as an attorney, then you have to have a law degree. You also have to have a license, because a license is required. So those are some examples of documents that have to be submitted, and these are all key documents. And of course, you have to submit the check for USCIS and ensure that all the forms are filled out correctly and signed and dated by both the petitioner as well as the attorney. So these are, I think, some of the documents that have to be submitted.
Okay, thank you so much. Thank you so much. And friends out there, please don't forget to subscribe to our channel, Immigration and Jobs Talk Show, because we keep having these interesting webinars. And this is the perfect stop for you, to know everything about immigration and job related details, anything, because we have experts joining us to tell us more and explain everything. We have you, in fact, you can even ask your own questions. So wherever you have joined us from, don't forget to ask your questions in the comments. We are very happy to take them. And if you're watching this show after it is being streamed, even happier to take your questions, because we are here to serve you and have your immigration doubts cleared by our experts. All right, so well, we had Samsonite and he is following up, so let's have his question first. And he's adding up saying 240 days rule is closed now and still waiting for approval. How will we approve extension now? And how will he apply extension now, as he doesn't have perm and has already maxed out?
He's in trouble. I mean, I don't have a magic wand unfortunately, to get him out of his fix, but he can file for a change of status. I mean, I can't help you with getting him an extension because there are certain limitations to that, right? You have to show either that the labor cert is pending for 1 year, which is not because it's been 10 months, or that the I-140 is approved. And there's no way of expediting it. So maybe he needs to leave the country and for that period of time until the I-140 gets approved, and then come back once it is approved with a H1 for 3 years extension. The H1 beyond 6 years is possible if the I-140 gets approved. So maybe it's time to just leave and then come back on a new H1. The other option is to you could also file for a change of status temporarily to a B2, and then hopefully by then in the next 6 months, you get your I-140 approved and you change back to a H1 from a B2, or you can change your status to an F1, and again change back from an F1 to a H1 once your I-140 is approved. So it may not be possible to get an extension directly, but these are some of the ways that you can alternatives that you can use.
Okay, thank you for taking that up, and I hope this time you've got your answer, Samsonite. All right, then, we also had Mahit. So Mahit is also having follow-up. So let's answer his first. Can I get any work authorization or any immigration status? I wanted to file some other visa status based on the incident that happened. Is it
Ah,
possible?
well, you could possibly file a U visa if there is a criminal case against. If there is a criminal case and you're aiding the police in as a witness in the criminal case, then it's possible to get a U visa. So you can look into that.
Okay, okay. And Samsonite says, "Thank you so much, ma'am, for explaining this patiently. This is helpful, and thank you, Immigration and Jobs Talk Show team, for your support." Thank you so much, Samsonite. Much love for you, and keep joining us. And don't forget to subscribe to our channel. All right, whoever's watching, wherever you're watching from, please don't forget to subscribe so that whenever we're having these interesting webinars, you can join in to ask your questions directly to the attorney. All right, so moving on, we have Shiva in LinkedIn asking, can I work directly with employer? I just got picked H-1B with my employer. That's it.
Um, yeah, you're supposed to be working for your employer if you got picked on the H1. I have to sift into these questions to find out what they're actually asking. It's like a USCI's RFE. Request for further evidence. They're like, send us all this information, but we don't actually know what they're asking for. You have to like read between the lines. I'm
Right.
just kidding, Shiva. Um, just some, something to lighten your mood. That's all. But I'm going to try and answer your question. So can I work directly with the employer if I just got yes, you can work directly for your employer at your employer's work site. I think that is what you're asking. As long as they have work for you, you don't have to be working for a third party client. That is only in the situation where your employer is a consulting company and they send people to work at other work sites. But you can definitely work for your employer as long as they have work for you, and they should be able to show that they have work for you by telling USCIS what they do and why they need you and documenting it.
Can
Oh,
you
I can't
provide
hear you.
insights?
Oh yeah, sorry, I couldn't hear
Sorry.
you for a minute.
Okay. Arya is asking, can you provide insights into how the H-1B cap filing process has evolved over the years and how can I adapt to these changes for success? Okay.
We can have an entire show on that
I
topic,
know.
but I will try to be brief. It has changed over time. It's has its ups and downs. They've been liberal at times. They've been um, very strict at times. It really depends on what the US government policy is at that particular time. So they open and close the gates based on the politics, based on how many people they need. Mostly it's just politics, depending on which government is in power. Um, when Trump's administration was in power, the everything had become difficult. Everything related to H-1Bs had become difficult. They were asking a ridiculous questions about, in RFEs, they were asking for just, documentation that was unnatural. In response to USCIS, we had to provide information that would normally not be available in the industry. They would, for example, ask for proof that there was job for that person for 3 years in a consulting situation, and it's not possible to get a contract for 3 years specifically. Contracts are given out for 1 year at a time, and then they're renewed in a consulting situation, right? So they would ask for that. They would ask for a detailed itinerary of where the person will work every single day for the next 3 years, and that's not possible either, because it's not possible for an employer to foresee exactly what the person will do on a day-to-day basis, um, for such a long duration of time. For example, in my office, if I have paralegals working on certain things, I always switch them around, right? Sometimes they work on green cards, sometimes they work on H1s, sometimes they might, be doing admin work. So, um, switching them around, doing different paralegal work is not something that I can envision, for the next 3 years, right? So it's like that, asking employers what the employees will do. It's sufficient to say that they'll be working as a software engineer, right? You don't have to say exactly where they'll be working, what they'll be doing. So anyway, um, then because of all this, there was then a few lawsuits filed, and there was a lawsuit in 2020, IT Serve versus Cessna, in which they said that the decision was, the judge said that you cannot be asking for detailed itineraries, and you cannot be, asking for contracts and work orders with all the clients that the beneficiary could potentially work for. So this was too burdensome on the employers. So now they don't ask for that information. So we see again there's a change in the way USCIS is processing H-1B cases. It's become more liberal now. Even their interpretation of what is cap and what is not cap has also become liberal. So you just have to adapt based on what USCIS's policy is presently, and an attorney can definitely help you um, figure out what the policies are for. Because first of all, you have to know what the policy is, and then file the petition based on what USCIS's expectation is. And that will not be written in the black letter of the law. You can't go to the Immigration and Nationality Act and look at all these things. It's based on experience, and it's based on some memos. USCIS sometimes sends out memos now and then over what they expect and how filing should be done. So that is an insight into how USCIS is presently reviewing cases. But I think most importantly, you need an attorney who has experience doing this,
Mm.
so that they can guide you through the process as it is as of that day, and tell you how to file a successful H1.
Okay, thank you. Yes, but we've had so many more discussions on this area. So definitely, check our channel out. We've had discussions, how can you adapt to, I mean, about the H-1B, how it has evolved over the years, and many other things we've discussed. So check out our channel. Don't forget to subscribe, and also stay with us because there's so much more to discuss. So maybe as you stay with us, you can explore more about the topic. All right, so let's move on. We have Roman on YouTube asking, can my husband get an EAD without my I-140 approval? My H-1B was approved in October 2022, filing for his H-4 now. Attorney says we need I-140 approval, but it's too soon for my employer to file permanently.
Yes, unfortunately, you do need an I-140 approval for your spouse to be able to apply for a H-4 EAD. So that's that. There's not much we can do.
There's no other way.
There's no alternative. You do need an I-140 approval.
Thank you. Thank you so much, Prashanti, for taking that up. And let's take one more before we go out for a break. And I think this one should be from Jolty asking, how does the H-1B cap filing process vary from applicants sponsored by different types of employers, such as universities, nonprofits, or for-profit companies?
So that's a good question, and even though I should be saying that it doesn't vary because USCIS is supposed to be looking at all cases and all petitions with the same lens, but they don't, and that is not something that they say, but in practice they don't. If it's an IT consulting company, there's often much more scrutiny, but I guess that's because that there is more fraud also in that sector, and a lot of H1s are filed by consulting companies. So they have to be careful for that. So they ask a lot of information. Previously, they used to ask information about employer-employee relationship, which they're not doing anymore, and that was mainly for IT consulting companies. But if you are a university or a non-profit or a for-profit company, generally this scrutiny is um, a little less, maybe, but you still have to meet all the basic requirements. You have to show that there is a job and that you qualify um, for the job based on your education, and that the job is a specialty occupation, and that the employer has the need to hire you. So they have to show that it's a valid job offer. The other advantages of nonprofits, I mean, universities at least, and nonprofits related to universities or nonprofit research organizations, is that the fee that they pay is different, and they're also cap exempt. So they don't have to go through the registration process, and they don't have to pay as much fee as the for-profit companies pay. So that's a big difference as well.
Okay, thank you so much, Prashanti, for taking that up. And friends out there, you can also directly contact Attorney Prashanti Reddy. Her details are on the screen. You can even call her in the number 212-354-1010. Once again, I repeat, 212-354-1010, or definitely mail her at prashanti@reddyesq.com. And don't forget to also visit her website, www.reddyesq.com. And of course, don't forget to also subscribe to our channel, Immigration and Jobs Talk Show on YouTube. We are covering the do's and don'ts of H-1B cap filing today. And stay with us, friends, because we still have so much more to discuss. So now we'll just go for a short break. And also, we are streaming in every platform that is on LinkedIn, YouTube, Facebook, and even on Twitter. So, yes, we'll just go for a short break. Don't go anywhere.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I'm Napasa Pradhan today with Attorney Prashanti Reddy, and she is a familiar face in our channel, and I'm sure that you have joined us in previous discussions with her. And for those of you who have just joined us today, she is an expert immigration attorney who has been practicing for over 25 years now, right, Prashanti?
Yes, yes.
And today we are discussing about the do's and don'ts about H-1B cap filing. So thank you so much for staying with us, and all you folks, for your questions as well. Keep commenting your questions. We are happy to take them up for you. And I am very happy that we have more questions from the audience, Prashanti. So let's take that already. Let's take this one from Dave on YouTube asking, I have my H-1B lottery selected with a consulting company, and right now my current company is ready to sponsor L-1B. Can I have both H-1B and L-1B visa processed parallelly?
Well, you could do one for consular processing, and you could do the other one for. Well, I don't know if you're presently in the U.S. or not. If you're not in the U.S. and you want to file two petitions, go ahead. You can do that, and then you can decide which one you want to use. If you're in the U.S., then it becomes a little bit more complicated because you'll have to file a two change of status applications, one to a H1 and one to an L1, and that becomes a little complicated. I wouldn't advise filing two petitions unless one of them was consular processing.
Okay. I hope, Dave, that is clear to you. If you have more questions, we are here. We'll be happy to take them. And moving on, let's take this one from Pinky. She's asking, please advise. Should I disclose my F1 visa rejection to on the H-1B application when my employer asks about visa denials while filing for H-1B? And will it affect my H-1B decision?
As far as I remember on the form, there is no question where you have to answer about your previous visa denials. I don't remember offhand, but I don't think there is. But if there is, there you should answer truthfully and correctly everything that's been asked. And I don't think an F1 visa rejection really had anything to do with the approvability of your H1B application, unless there was something related to fraud, or even then, most often than not, your visa rejection should not have any bearing on your H1B application.
Okay. Okay. Thank you for taking that up for Pinky. And Prashanti, there's one question I wanted to ask, and that is, can H-1B applicants look for jobs with different companies, while waiting for their visa approval, considering that only a few applicants get selected?
Um, so you have to basically work with the employer that um, does your registration, and you can do more than one registration. Of course, you can do multiple registrations, and if you do more than one registration, then um, you know if you get selected, then any of your companies that you did registrations with can file your H1, and then you get to decide who actually you go with. So that's how that will play out when you have more than one employer do your registration. And once you get the H1 approved, now if you want to move to a third company that hasn't done your registration, you'd have to work for the company that has done the registration and got your H1 approved, and then you can always file a transfer to that third company as well.
Okay. Okay, thank you for taking that up. Let's move on. We have more people asking questions. So this one is from Sam on YouTube asking, as a Pakistani national on my second year of H-1B with a cap exempt nonprofit, my employer initiated my green card process. What's the estimated processing time?
So the estimated processing time for a nonprofit or a for-profit, if you're filing the regular labor cert and I-140, is the same for everyone. The labor cert takes about 6 to 8 months. If there is no audit, if there's an audit, it can take longer, up to a year even. And then the I-140 can be filed in premium processing, which takes 30 days. If you don't file premium processing, then it can take a few months for that I-140 to get approved. And then it depends on whether your visa number is available or not. If the visa number is available for your category, and you have better shot at it being available being a Pakistani national when compared to an Indian national. So if you file an EB2, it's possible that your visa might become available soon. So if it is available, then you can file the third step, which is the 485. And the 485 takes about 10 to 12 months to get approved.
Okay. Patience is virtue, friends. No matter what, you just have to wait and don't worry, there's always a way out. So just stick to the plan, do what's required, and there'll always be a way out. Let's take this one on LinkedIn. And this one is from Jitendra asking, is it costing $5,500 to file H-1B petition this year?
Yes, the I haven't added it all up, and it also depends on number of employees that the company has, but it is costing more this year. The 460 fee, the base fee has been increased, almost doubled to 780, I believe, and they've added on a new asylum fee, which is $600 for if you have over 25 employees and $300 if you have under 25 employees. So right there you see that there's an addition of 1,000 to $1,500. So the previous fee was about 1,700 to 2,500, and that's gone up by about $1,000 depending on the employee count. So it has gone up to close to 5,500. It can be even more if your company has over 50 employees. So yeah, that sounds about good estimate.
Okay. Well, it's very interesting, and I mean, so quickly the fee was hiked, right? I'm sure people out there were shocked and surprised, and maybe has had a bad impact also on so many. Maybe they were planning to apply, but they couldn't. Any comments, Prashanti?
Yeah, so the fee hike doesn't so much come as a surprise. It was sudden because they
Sudden,
published it in
yes.
the register and then immediately did it. But they've been trying to do a fee hike for a while, and somehow or the other it always got derailed. So this year the fee hike finally happened, but it was expected among the community, at least people who knew about it, the attorneys and etc.
Hmm.
But it just we didn't know how much it will be increased by, so it's quite a big increase, almost double. The basic fee is almost doubled, and then they've added a new asylum fee, which no, I don't think anyone was expecting, which is $600 more. So the maximum fee would be 460 plus, I mean 700 plus 500 plus 1500 plus 600. You do the math. So that's the total fee. Uh,
Should take the
so it's
calculator out, but yeah, just kidding.
yeah, yeah, yeah. But it's quite a significant increase in the fee.
Okay, yes. And Dave had asked if he can have it parallelly. So he's saying that uh he I am outside India, by the way, and thank you.
Oh,
So
okay.
will the answer
Yeah, so
change?
that's so he can file both together and then decide which one he wants to enter on.
Okay, okay. All right. So now let's take up this one from Emilia asking, what strategies can I employ to overcome the chaos and uncertainties surrounding the H-1B cap?
I think we discussed in the previous question the strategies, right? Do you want me to go
Yes.
through it again?
No, it's good. Thank you, Prashanti. And Amelia, I'm sure you were here. So if you were not, you can just, rewind and watch what we just discussed with Prashanti. And thank you so much, Prashanti, for that. All right. So Shiva is asking, can I work directly with employer? I just got picked H-1B with my employer. Sorry, I missed your answer because of network issue. Okay, Shiva, to you too. I mean, you can always go back and watch because this is streaming, but it is permanently uploaded. So even after we have finished the streaming, you can go back and watch what Prashanti just answered. Okay, so let's move on, and we have okay, we still have Shiva asking, after getting H-1B picked, for how many months I should be with my employer for H-1B transfer.
Well, there is no time limit within which you're supposed to file where you can file the transfer, but you want to make sure that uh, USCIS doesn't suspect that you never had a valid job offer with your first employer, right? But there is no minimum or maximum time uh, limit within which you need to file your next H1. The only thing they look at is whether you have pay stubs. So you would have to stay at least long enough for them to give you a pay stub
Hmm.
so that you can file it with a pay stub.
Okay, okay. Thank you so much, and thank you, Shiva, as well. Stay with us. I hope you are getting more doubts cleared. And well, let's I want you to explain, maybe if you could shed some light on the viability of in-house projects, in the context of H-1B visa petitions, Prashanti. So specifically, what criteria are considered to determine the legitimacy of an in-house project?
Well, if an in-house project is legitimate, it is easy to show that it's legitimate. The question is being asked because a lot of employers submit uh, fake in-house projects to show that
Mhm,
they have employment, and then what they do is they once they join the company, then they place them at a client, and USCIS is aware of this, and USCIS is looking for a pattern where this happens, and they're coming after companies that say that they're hiring 10 people for an in-house project and immediately transfer them off and then make them work at a client site. So be aware that USCIS is aware of this practice and use it. Don't do it at all. But if you have a genuine in-house a project, because you are a product development or software development kind of company, then that will show in the nature of your business.
mhm. Talking more about it,
Uh,
yeah, sure. Sorry for interrupting. Actually, you're stuck, Prashanti. Yeah, I think there was some network issue. You got stuck. I'm sorry. Could you repeat what you just said? Oh, I think there has been. Okay, there you are. Sorry, Prashanti, there was some network lag from your end, but I can see you, though you're not appearing here. Yes, you are now. So, what did you just say? We just missed because of network issue.
yeah. I just saw a message which said connection was lost. Sorry about that, folks. But I was. Let me just start from the beginning because I don't know which part our audiences heard and which part they didn't. So we just have to make sure that the project is genuine because the nature of the business of the company will give us a clue as to whether the project is genuine or not. Because if the company is mostly doing just consulting based on their website, description, then USCIS is going to kind of look at that project skeptically. But if they're actually into product development, into software development, then and that this is one of the several products or projects that they are right now taking care of, then that should be easier to prove. And generally for an in-house project, you would have a project report, you would have a contract for who you're developing the project, or at least you'd have letters of interest of people who are interested in your project development, in your product development, because obviously no one spends money and puts money into a product before doing the market research into what the viability of the product is and getting some kind of interest from potential clients. So you should either have a contract or a letter of intent, screenshots to show the progress of the development of the product. Maybe you've used outside vendors, so you can show invoices submitted or payments sent to the outside vendors for taking care of part of the project development. Maybe you have purchased software that you're going to be using to develop the project. Maybe you have an app and you're in the app store. You've purchased an app that can be shown. Maybe you have a patent for the project that you're developing because it's unique. That can be shown as well. In the general, progress of the projects, the screenshots, the project report, as I said, as to what the project does, etc. So these are some of the documents that can be submitted if the project is genuine. There's no dearth of information that you can show that proves that the product is genuine. But
Thank you, Prashanti, for
but
taking.
I guess unfortunately the standard of proof is a little higher here because just that USCIS sees so many fake projects that they're going to presume there's a presumption that the project is fake, and almost like the marriage-based presumption. But they don't say it as such. But that's how they look at these cases.
Okay. All right. Thank you, Prashanti, for that detailed answer. And folks out there, wherever you're watching us from, please hit the subscribe button, and also the bell icon, so that whenever we go live and whenever we update about immigration and other job related topics, you can always join us and be the first to know, right? So, Prashanti, we have Govind on YouTube asking, is there any second round of lottery in 2025? Round one, I had not got selected. I did not
Sorry
get
about
selected.
that. Sorry about that, Govind. Hopefully, you'll have better luck next time. It's hard to say whether there'll be a second lottery or not. Generally, USCIS will see if all the H1 numbers have been used up. So the registrations, it's not necessarily that everybody's um, case will be filed. That means not everyone who gets accepted in the lottery will file their H1. So if they don't, and then USCIS determines that there's not enough filings to use up all the numbers. Usually they select more registrations than they require. So if there's 85,000, they usually select 100 plus registrations, 100,000 plus registrations, because they account for the fact that there'll be some people that don't file, a certain percentage of people that don't file. But if they find that the numbers that they accounted for is still not enough to meet the cap, then they will have a second lottery. So last year they did have a second lottery, but that was an unusual situation where uh, nobody filed their anybody. A lot of people did not file the H1Bs after they got picked because of multiple duplicate filings, multiple registration issues. So a lot of
Okay.
companies were scared to file, so they didn't file. So let's see. We have to wait and watch.
There's actually a follow-up. Govind is asking, is there any updates of how many people got enrolled for the lottery?
We don't have the numbers as yet,
Okay.
but
Govind, you just have to.
we just have to wait. Yeah, but we have a pick rate. It's about 20 to 30% is the pick rate. So based on that, you can kind of do a calculation as to how many might have filed. About 350 to
Approximately.
400,000 maybe. Yeah.
Right. Right. But Govind, I'll just say don't forget to subscribe to our channel. Maybe we will be the first to let you know how many people got enrolled for this lottery. Okay. And moving on to Amar asking, hi, my wife has an H-1B visa stamped on PP is I don't know, EXP September 2024. Filed H1 to H4 COS. This is very cryptic, Prashanti, but let's try it. And it is approved. Can she travel to Mexico and come back without H4 visa stamping? And how H4 approval at POE? Okay.
So I'm just going to read it again. My wife has a H1B visa stamped on the passport, I think, expires 2024. Filed a H1 to H4 change of status, and it is approved. Can she travel to Mexico and come back without H4 visa stamping and show H4 approval at the port of entry? That's POE. So yeah, in order to travel to Canada and come back, if you're traveling for vacation, you don't have to have a visa. You can travel without a visa with your I-94. So yes, it's possible.
It is possible. Amar, you can travel. Okay. Let's move on to this one from Govind asking. Oh, we've already taken this. Sorry, sorry. We have Michael Chen asking, I am employed on a cap exempt H-1B and never gone through the lottery. Can I work for a cap subject on a concurrent H-1B? If so, what is the maximum number of hours?
That's a good question, Michael. Yes, you can work on a concurrent H1 for sure. Um, because you are working on a cap exempt H1, as long as the second H1 is concurrent, you can, and there's no maximum or minimum number of hours. It has to be something that is doable, right? So if you have two full-time jobs, is there enough number of hours in a day to have two full-time jobs is the question that USCIS will look at when they're approving the petition. So make sure it's something that is believable, doable, and then you can have those number of hours in your concurrent H1.
Okay. Michael, all the best. We have Jitendra on LinkedIn still asking more questions. I got a full-time employment where company is filing my old H-1B transfer. Currently, I am on L2s, so L2S. So this is a change of status. I have also been selected in H-1B lottery through a consultant this year. Can I ask my full-time employer to utilize the H-1B visa picked in the lottery instead of utilizing the old H-1B?
I got a full-time employment where companies filing my old H1 transfer. Uh, I have been selected. So again, I'm going to answer based on my understanding of the question. It looks like the person is already cap exempt, Jitendra. So I'm not sure why you filed a lottery again if you're already cap exempt, but you could do either. You could file your H1 under the lottery, or if you're cap exempt based on a previous H1, then you could do that as well, as long as the previous H1 was never revoked for fraud. And I would also caution you to make sure that the previous H1 was, you worked on the previous H1 less than 6 years ago, though USCIS has been very liberal with what they define as cap exempt and what is not. So you could do either.
Cool. Cool. And here's a request, friends, wherever you're joined us from, please tell us where you've joined us from so that we can have better answers for you. Right, Prashanti? I mean, knowing where they are, you can give better answers, right? Whether they are in US or outside the US, which country or city even, let us know. We'll be very happy to answer more precisely. All right. So we have Vihan on YouTube asking, how does the H-1B cap filing process differ for applicants who have previously held H-1B status?
Well, if you are previously on a H1, you do not have to be filing a H1B under the cap. You should be H1B exempt. Um, so that's the first step, just to see whether you're exempt, and you're not exempt if the H1 was revoked. And in some other instances, there is a little bit of gray area in their interpretation of who is exempt and who is not. Um, it's possible that you may not be exempt if you filed your H1 more than 6 years ago. But again, I've seen some approvals even in those situations. So the main issue is, why are you filing under H1B cap if you've already held a H1B status? But even if you are, there is no difference really in the processing. It's the same processing.
Okay, okay. All right. So let's take this one up from Raghav in LinkedIn asking, can you share your thoughts on employment authorization in compelling circumstances?
Yes, good question again. This is, people who say they are in their 60 days grace period, and the 60 days grace period got over, and they can't leave because they have compelling circumstances, uh, loss of revenue may not be looked at as compelling, but maybe they have children, US citizen children, spouse, maybe there's some medical condition that and treatment is going on whereby they need to remain in the country. So, there could be many reasons for compelling circumstances. But even if so you're able to apply for an EAD under the compelling circumstances to remain in status and continue working. That's what it is, the compelling circumstances employment authorization. But please remember, the biggest disadvantage of this is that it doesn't give you any status as such. It's simply gives you a EAD and allows you to stay in the country. But if you should want to change status, you cannot change status. You cannot file for a change of status. So you'll have to leave the country and then come back on a fresh visa. Second, the processing time is quite long, so you might be ending up staying for a while, and then if it gets denied, then you would have stayed out of status for all this time. So that's processing time is another concern when you're applying for this particular relief. And also compelling circumstances, is something which is up to the interpretation of USCIS more or less. So it's difficult to determine whether your case will get approved or not. So that's another thing to keep in mind. So these are the disadvantages. Of course, the advantages are obvious. You can remain in the country, and these are the disadvantages that you have. So think about it before you go to this route of EAD.
Thank you, Prashanti, for taking that up for Raghav. And let's take up another one. This is from a LinkedIn user, Anonymous, asking, I am in my second year of H-1B and my contract is ending in 2 months. Is there an easy way to bridge the time between now and my new role, which I will find? I know I have um, to be on C2C for any role which is not with my current agency. Is there any other option?
This is not really. This is more a logistics question, not an immigration question. Uh, but if you're in your second year of H1, you still have another year before you need to file an extension. And of course, if your contract is ending in 2 months, your company has to continue paying you, even if you're on the bench, and USCIS might accept that as status. But I think the best way is to find another contract as soon as you can. And in the meantime, have your employer continue to put you on the payroll, and that should be sufficient for you to maintain status.
Okay. Okay. So let's take this one from Ganesh on YouTube asking, I was trying to fill form I-539 online. I'm almost out of 60 days gap and was filing this for H-1B to B-1 B-2 status change. I couldn't find H-1B option on the online filing option. Can you please guide, please? Yeah.
No, so that's a different application. Change of status from B2 to H1 is a different application. That's not an I-539 form. You first fill out the I-539 form for change of status to a B2, H1 to a B2. And then once that is filed, then once you get a job again, you have to again file for a change of status from a B2 to a H1. And this time you have to do it on an I-129 form. And the B2 has to be, it could be pending, or which is makes it a little bit more difficult, or it could be approved, based on which then you can file the H1. So there is, right now, if you're just doing the change of status from a H to a B2, you have to fill out the B2, and I'm not sure what you're not able to find out. Filling this for H1 to B2 change of status, couldn't find H1 option. There is no H1 option. You have changing to a B2, and you have to give your present status as H1, and there is a column where that asks you for your present status. So hope that answers your question.
I hope so too. Well, thank you, Ganesh, for your question, and thank you, Prashanti, for taking that up. And maybe this could be the last one. You know, asking, how does the Sridhara Alavala case highlight the challenges faced by H-1B visa holders in navigating USCIS decisions regarding employer misconduct? What do you have to say, Prashanti?
Well, basically, I don't want to discuss the case as such because I haven't gone through it in detail. But in general, with reference to USCIS decisions regarding employer misconduct, there have been many in the past few years. And all I can say is that, employers have to be careful. Sometimes, the way when we do business, the normal course of doing business is quite different from what USCIS expects us to do. And some of the rules that USCIS has makes it quite difficult to do business, especially for consulting type situations in consulting companies. So,
Mhm.
employers often cut corners or do things which they're not supposed to do. And sometimes it's just, there's so much fraud in the market that even if there's no fraud by that particular employer, USCIS just presumes that there's fraud. There's a
Right.
recent situation in which a client called me where they were actually audited first by USCIS because they had a MSA with a particular client, and it's an ongoing MSA, so they brought in 18 people over the last 5 years on that MSA. And some of the people did not work for that particular client, but worked for, another client when they came into the US. So that kind of USCIS audited them because of that. But it just so happened that so USCIS is looking for a pattern where employers are using incorrect reasons to bring them in here. So they're saying that, oh, we have a contract with XYZ client, and they're going to be placed at that client. So oftentimes, two things can happen. One is things change and they're not placed with that client and they're placed elsewhere. And sometimes the employer may have that contract, but they may not have job openings with that client at that particular time, but they're using that MSA. So employers have to be careful when they submit a certain document to USCIS. It might just be better not to submit anything and file a skeleton petition rather than boxing yourself in and submitting a particular document, and then if you're not sure 100% that the employee is going to work there. It could be that the employer is likely to work there because you have openings, and this employee fills until the employee actually comes to the US, confirm that they can work there in many situations. So you might be better off just submitting several contracts, open contracts that you have, and saying that there's a possibility that they might work at any of these clients, and we are confident that we'll be able to place them at one of these clients, and they'll be working remotely, so that's the work location. So you're better off doing that rather than putting in documentations which are incorrect, or putting in documentations where the circumstances are likely to change. Just file a skeleton petition if you're not sure, and then if you get an RFE, then deal with it accordingly, rather than putting in information that may get you into trouble later on.
Right. So the do's and don'ts. There you go. And well, last but not the least, Prashanti, I mean, if you can maybe share an illustrative case study, from your experience, from among all of your cases, maybe that exemplifies common errors or missteps made by H-1B petitioners, highlighting key lessons to help others who are watching us right now, avoid similar pitfalls, maybe.
Um,
Anything significant.
well, common errors is not signing a check, maybe not signing your I-129 petition. I just mentioned one error, one issue with the employers when they, providing documentation which are incorrect. Don't do that. Getting an evaluation done might be a useful thing to do, because they are asking for evaluations for foreign degrees more and more, and they're sending RFEs on that. So maybe get that evaluation done beforehand, because if you try to do it in June, all the evaluators are busy. So try to get that done now. Even if you're filing the petition in June, get all the paperwork done now. Make sure that if you're filing under the master's cap, that the master's degree has been completed as of the date of filing the petition. Otherwise, don't file your petition because your H1 will not be approved. So these are some of the, I think, uh, key do's that I can, add to in addition to what I said earlier. Thank you.
Yeah, you have a great day then.
Thank you. Take care. Bye.
All right. So, friends out there, if you want to contact Prashanti directly, also, you can contact her, email her directly the questions. That is Prashanti at reddyesq.com. You can even call her in the number 212-354-1010. And I'm also available, friends. So, write to me. You can write your questions, email me, or even call me at 408 335-6444, or just email me at nipa@higheritpeople.com. We'll be very happy to answer all your immigration and jobs questions here on Immigration and Jobs Talk Show. And yes, don't forget to subscribe to our channel, because we keep having these very interesting webinars with experts and attorneys. And I'm very happy to tell you that very soon at 2 p.m. EDT, we are going to have another one. And I'll just tell you to subscribe and join, okay? I'll be there. So see you then, I'll say. And yeah, thank you so much, all you viewers, wherever you've joined us from. And here's an earnest request once again. Let us know the city and state you have joined us from, so that we can give you better answers and more precise answers. All right, then. And this is it then for today. You all have a good day ahead. And this is Nipa signing off from Immigration and Jobs Talk Show for now.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.